On Law Weekly today, we're talking security, corruption, and issues affecting the legal profession. Our guest is a woman of many firsts, Chief Solanke, first female senior advocate of Nigeria. We also have the views of some senior legal practitioners on Goal 16 of the SDG and suggestions on what can be put in place towards the realization of the goal by the target date of 2030. Plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Sheyeli. The first female senior advocate of Nigeria, the first commissioner of Western State, and first chairperson of the Western Nigeria Television Broadcasting Corporation, Chief Mrs. Solanke, is indeed a woman of many firsts and mentor to many. A recipient of the National Honor of the Commander of the Order of the Niger, Chief Mrs. Solanke also holds the traditional title of the Yeye Mofin of Ife and is widely respected and admired as a legal giant. She has won many awards locally and internationally, and her voice is a much sought-after one in the legal profession. I began this interview with her by asking her views on the security situation in the country.
The situation of insecurity is disastrous for this country because we have to be safe to be able to do anything. We have to be secure. I wanted to go to Ile-Ife last year because of the mayhem that was taking place on the Ibadan-Ife Express. I had to get in touch with the police to get armed escort for each of my 2 vehicles. It's all right that I could do that, which were those who could not do it. So it was tremendous relief for me to read about the Operation Amotekun, because it is a reaction to the desperate situation of insecurity. And I was very happy to read in the newspapers that the Western Zone, also the Eastern Zone, communicated with the president that they were also going to establish their own. So it's very good that the leaders are taking action. Now, when you break it down, what is causing all this? Poverty. Poverty is at the root of many of the evil doings of people now. So Nigeria has to find a way of creating jobs for the people. If people are poor, they have no food to eat, then they indulge in all kinds of criminality. So we want to really cooperate and encourage those governors in the Southwest who have made a determination to do something about it. It is gradually restoring confidence in the people to travel. I know that there are always aspects of any situation that could be negative or positive. But even though the Inspector General met with the governors, and they came out with a decision that it should not be a regional outfit, it should be on a state by state. Well, that's all right, because the states can always collaborate. Even if it's by state, they can still work together, collaborate. And that is what every part of the country should do. And then parents have to make sure that they impress upon their children to avoid dangerous situations. I read of people, of young women on the street, they're going from one place to the other. They're kidnapped, they're abducted, they're raped. Nobody should be out. Parents should make sure that their children are not out on the streets at night. So that's one very important mission that parents should undertake. And indeed, teachers also must constantly tell children, their pupils, that they must be very careful about the situation in the country, and they mustn't expose themselves to danger.
Let's talk, Mana, about issues of the profession. I want to talk about issues of discipline and integrity among lawyers and judges. It's a big issue. We've seen some judges, some senior advocates being held in on corruption charges, money laundering charges. Every day people are condemning, so much so that even when judgments come out, people don't know whether the judiciary has been tainted or corrupted in giving some of those judgments. It's that bad. How do you think, Ma, that we got to this stage?
When I joined this learned profession, now that was 1963, 56 years plus now, there was no whisper or allegation or suggestion of corruption. But gradually, in the last maybe about 3 decades ago, few accusations, magistrate level. Then about 2 decades ago, few accusations about the High Court. And then about maybe a decade ago again, Court of Appeal, Supreme Court. It's really something that grieves my soul that anybody could be speaking about judicial corruption anywhere. Anywhere now they talk about it. And in all my lectures, I always say that not all judges are corrupt. There are some of them who labor night and day to give of their best and to make sure that judgments are based on evidence received and the applicable laws, nothing else. I think we should stop applications for judgeship. That's what's going on now. And it should not be based on who your father is, or who your mother is, or where you come from. It should be purely knowledge and merit. We shouldn't. So there's a lot of problem in the appointment of judges. From the High Court, they go to the Court of Appeal, they go to the Supreme Court. Many are good, but many are giving us concern.
You talked about the problem with the process of appointment, and you say that it should be merit-based.
Yes.
But is that what aids corruption, because the wrong people are getting
Oh,
there?
yes, certainly. Certainly, because when you are invited, not only your knowledge of law is taken into account, your reputation, your integrity, in the hope that you are going to be what they are seeing in you. So it's not only law, it's the character. They also observe your character and your reputation. Yes.
Another issue I wanted to talk about is the slow pace of speeding
adjudication.
Yes, adjudication. What do you think, Ma, that can speed up the process? Is there anything that we can do differently?
The delay in the court system is abysmal. I have a family case which has been there since 2007. But sometimes corruption also delays cases. Files get missing in the registry. And when you do not go to court, when you don't have notice of hearing notice, you don't go to court. The files get missing. You have to agitate and appeal to them before you get the fine. It's corruption. The registry is another place where we need a lot of, reform. It's a national problem. Corruption is a national problem. But what is worse for the law is that the law is supposed to bring salvation to the country. If the law fails, the nation fails. May we never fail. Let me focus on the judicial reform. Now, many cases, many appeals, we should never reach the door of the Supreme Court are there. I mean, somebody has a case where some goats were killed or something, and that got to the Supreme Court. Tenancy agreements, you know, matters like that should never get to the Supreme Court. And it is important for the Supreme Court itself to engage in self-criticism, self-awareness, self-assessment, to address the loss of confidence of the people in the Supreme Court. That is where our salvation lies. The Supreme Court is there to make sure this country is as it should be. So if anything goes wrong with the Supreme Court, we are in trouble. If anything goes wrong with the court, we are in trouble. I mean, look at the way the former Chief Justice of Nigeria, Onogen, the Honorable Justice Onogen, was removed. I'm not advocating for anybody, for any wrongdoing. No. I'm advocating serious breach of due process. The Chief Justice of Nigeria was removed on a nocturnal order of a tribunal. The National Judicial Commission never even was involved. This, I mean, by the time it got involved, it was too late. I still cannot get over it. That is something that history is going to condemn, and it's going to be something that we must make sure doesn't happen again.
I wanted you to say something about electoral reforms, because you've talked about judicial reforms and what the things, some of the things that we should consider. Electoral reforms, because a lot of people say that politicians are the ones who corrupt the judiciary.
The Supreme Court should have nothing,
To do with
nothing whatsoever. That's my own recommendation. That's my own recommendation. It has nothing to do with politics. Politics. When you hear the word politics, run. So I don't want the Supreme Court to have anything to do with any level of, election. No. Another area that we want to watch is the enforcement of human rights. Human rights are being, they're not being enforced in Nigeria sufficiently. Even environmental right is part of human right. I don't know what they're doing in the, oil polluted areas of the country. And another thing that I want to stress is that when you talk of environmental right, in other countries, they are finding how they can get rid of plastics. Plastics are destroying oceans and rivers. All when you go on the street, look at the gutters in Nigeria, full of plastics. We are so oblivious to what is happening abroad. Plastics came on about a decade, 2 decades ago, but it's causing havoc.
They're everywhere.
To the environment. But there are countries who are really now in the process of removing them and stopping the production of plastics. So, and then on corruption, because we spoke about it before, we need to, when Kemi Adeosun, when she was Minister of Finance, she introduced whistleblower policy, and it achieved so much. She left, and then that's the problem with Nigeria, lack of continuity. They're still receiving money, but nobody is really talking about that. That's where the media comes in. And another thing that we can do on the basis of corruption, you should have ombudsman. Somewhere where ordinary people can go and report. Government should sit down, think about how they can have ombudsman, whether it's every state, whatever. But ombudsman, where people can go and report, and action is taken by those, to whom you have made, yes, to take action over it. So, ombudsman, whistleblower, please don't let them just disappear. Speak about it. That's all you can do. When you have focused attention on it, then we know that you've done your part.
Welcome back. And from that interview, we move on now to the views of some senior lawyers on Goal 16 of the Sustainable Development Goal. Goal 16 is on peace, justice, and strong institutions. Many Nigerians agree that no matter how many other goals the country achieves, without peace and justice, everything else can so easily come crashing down. But what are the barriers to achieving this goal, and what areas can the country improve on if the goal must be met by the year 2030? Law Weekly spoke to some senior legal practitioners to get their views.
The greatest challenge to us as a people is that the will is not there to implement whatever we agree. You remember under the late General Sani Abacha, we talked about Vision 2020. We're now in 2020. What can you point to that we have achieved in that regard? Does it have to do with us as a people, or does it have to do with institutions? Institutions are manned by people. I remember what President Barack Obama said in his visit to Ghana when he was talking about African leadership. He said the greatest challenge to Africa is our inability to build strong institutions. But human beings actually man these institutions. So if you're not disciplined, if you don't have the goal, if you don't have the zeal, if you don't have the enthusiasm, if you don't have the conviction, how then do you implement all these goals? So clearly it has to do with our weaknesses as Nigerians. And the only way this can work is, one, do we believe in it? Two, how much are we prepared to commit to it in terms of funds, in terms of orientation, in terms of awareness? How do you build institutions that are not funded?
I think moving forward, any project that Nigeria is undertaking should have or incorporate the people. It must be people-driven. It is not just a government policy. If you look at Nigeria as it is, both the political arrangement and the economic development, policy inconsistencies, and all of that contributes towards nation's growth. So if Nigeria as a country wants to progress or want to achieve a particular set project, people-oriented projects, people must be part of the policies of the government.
We discover that our laws are not being enforced to its optimal level. What I mean by this is that sometimes we find out that the person who is to enforce the law is the one that is breaking the law. So how will the law be enforced? Secondly, you find out that the person that is supposed to enforce the law does not have the facilities to enforce the law. Like I do a lot of things with Nigerian police. You discover that even the police, sometimes you go to their stations, they don't have statement papers to take statement from the suspects and from the complainant. And so many of those things, where there are no facilities for the enforcement agencies to enforce the law, to encourage them to enforce the law, you find out that the enforcement mechanism will be very, very weak. And that will affect peace. That will affect development. And the various institutions we have today will not be strong enough because their background, which is the enforcement mechanism, is not strong.
And on the home stretch, let's turn our attention now to some of the legal stories we're tracking at this time.
We begin with the report that the Supreme Court has dismissed an application for review of the judgment which sacks the governorship candidate of the All Progressives Congress in Bayelsa State, David Leon, and his deputy, Senator Biobrakuma Degi Eremianyo. At the proceedings on Wednesday, the 26th of February, Mr. Leon and APC in the applications, argued by two senior advocates, Afeba Balola and Wole Olanikpekun, asked the court to review and set aside the judgment which voided their participation in the November 16 governorship election. Afeba Balola told the court that it has inherent powers to set aside its own decision because the judgment was a nullity on account of the denial of his client's rights to fair hearing. Wole Olanikpekun argued that the Apex Court erred in law when it invoked Section 36 of the Electoral Act to disqualify the APC's participation in the election. However, Counsel to the People's Democratic Party, Tayo Oyetibo, also a senior advocate, argued that the applications by the APC and its governorship candidate were a dangerous invitation to the Supreme Court to violate Section 285 of the 1999 Constitution for the court to sit on appeal over its own matter. He also said that the Apex Court was right in disqualifying Leon as the governor-elect because Section 187 of the 1999 Constitution is clear and unambiguous to the effect that a governorship candidate who has no deputy is not qualified to contest any governorship election in Nigeria. After taking arguments from the parties in the matter, Justice Amina Algi, who read the judgment, held that the application lacked merit as the decisions of the court are final and no court on earth can review the judgment. She added the applications are frivolous and vexatious and awarded the cost of 10 million naira each against the applicant to be personally paid by their counsel to the PDP, Governor Doye Diri and his deputy. The total sum to be paid by the lawyers is 90 million naira. From the Supreme Court, we move to the Federal High Court in Abuja, which has sentenced the former National Publicity Secretary of the People's Democratic Party, Mr. Olisametu, to 7 years in prison. Justice Okonabang handed down the sentence in his judgment on a 7-count charge of money laundering and criminal diversion of funds to the tune of 400 million naira. The trial judge sentenced Metu after convicting and finding him guilty of all the counts brought against him by the Economic and Financial Crimes Commission. This followed the protracted trial of the former PDP spokesman with his company Dextra Investments, which lasted over 4 years and witnessed a series of drama and adjournment over health-related matters. Apart from the jail term, the trial judge also ordered Metu to pay a fine of 375 million naira, while his company Dextra Investment is to pay a fine of 25 million naira, after which its account would be forfeited to the federal government and the company dissolved. In Lagos, a federal high court has fixed April 27 for its judgment in the case filed by the Economic and Financial Crimes Commission seeking the final forfeiture of 2 houses in Ilorin, Kwara State, belonging to a former Senate President, Dr. Bukola Saraki. Justice Rewan Aikawa fixed the date after listening to the arguments for and against the final forfeiture of the houses to the federal government. In its submission before the court, counsel to the EFCC, Rotimi Oyedepo, said the former Senate President spent about 1.09 billion naira on the 2 houses, funds which he alleged were stolen from the coffers of Kwara State. The anti-graft agency claimed it had evidence that Saraki, who was Kwara State's governor between 2003 and 2011, diverted not less than 1 billion naira belonging to the state. It asked the court to make a final forfeiture order of the houses, a move that Saraki's lawyer, Mr. Kehinde Ogunwumiju, a senior advocate of Nigeria, vehemently opposed. Hassan said 252.2 million naira out of the 1.09 billion naira used for developing the property represented what Saraki was paid for the development of a 5-bedroom apartment, which he was entitled to as a 2-term governor of Kwara State. The council also pointed the attention of Justice Aikawa to the Governor and Deputy Governor Payment of Pension Law 2010 of Kwara State, which stipulated that an elected 2-term governor of the state was entitled to a 5- and 4-bedroom duplex respectively at any location of their choice within Kwara State. He therefore asked the court to dismiss the EFCC's application for being an abuse of court processes, saying the same issues had been taken before the Code of Conduct Tribunal, the Court of Appeal, and the Supreme Court, where Saraki was vindicated. And we round up with the report that a former governor, Akinwumi Ambode of Lagos State, filed his notice of appeal hours after the Lagos High Court struck out his application seeking a restraining order against the State House of Assembly. In the notice, the former governor is seeking an order of the court restraining the lawmakers from going ahead or taking further steps in respect of the probe pending the final determination of their appeal. The former governor also wants the court to make an order restraining the lawmakers from taking any steps that will deprive him of his personal right to liberty pending the determination of his appeal. He lists 4 grounds of appeal which, amongst other things, states the court erred when it held that his suit was premature, does not disclose a reasonable course of action, and that the court lacked the jurisdiction to entertain it. He also submits that the court was wrong in holding that the exercise of the lawmaker's powers of investigation under Section 128 sub 1 of the Constitution is subject to his right to fair hearing as guaranteed by the Section 36 sub 1 of the Constitution, especially when his right was being violated. He has asked the appeal court to set aside the decision of the Lagos High Court and an order remitting the matter back to the Chief Judge of Lagos to reassign the case to another judge for trial.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Shola Sheyeli. See you next week.